MRL3701, Hockly's Insolvency Law, Chapter 12, Impeachable Dispositions. Introduction. In addition to being vested with the property belonging to the insolvent at the time of sequestration, the trustee has the means of recovering certain property alienated by the insolvent before his sequestration. The trustee may ask the court to set aside certain dispositions made by the insolvent before sequestration and may, in certain circumstances, treat as void the transfer by the insolvent of his business before sequestration. These topics are discussed in this chapter. Number 12.1. Meaning of disposition. According to Section 2, the term disposition means any transfer or abandonment of rights to property and includes a sale, lease, mortgage, pledge, delivery, payment, release, compromise, donation, or any other contract therefor, but does not include a disposition in compliance with an order of the court. The following should be noted in this regard. Number 1. Property, according to Section 2, means movable or immovable property, wherever situated within the Republic and includes a contingent interest in property other than the contingent interest of a fiduciary, heir, or litigee. The definition includes foreign assets. The purpose of the expression wherever situated within the Republic is not to limit the operation of a sequestration order to property within the Republic, but to extend it to property beyond the territorial limits of the court which granted the order. Hence, property includes property situated outside the Republic. Number 2. There was formerly some uncertainty as to whether the repudiation of an inheritance, that is, a bequest or a legacy or insurance benefit, amounts to a disposition for purposes of the Act. The Supreme Court of Appeal has now laid down authoritatively that the beneficiary in this type of case merely has a competence or power to accept the inheritance or benefit in question, and that until he does so, it does not form part of his estate. Consequently, in repudiating, that is, refusing to accept the inheritance or benefit, the beneficiary does not abandon any right to property. For the same reason, a change of beneficiary under a life insurance policy from the insured to a third party does not amount to a disposition by the insured. Nomination of the third party beneficiary merely gives him a power or competence and hence is not a transfer or abandonment of any rights under the policy. Number 3. A disposition includes a contract providing for the alienation or abandonment of rights to property. This is sometimes referred to as an uncompleted disposition. See for an example Section 26, subsection 2. A contract of suretyship, although not specifically mentioned in the definition, is a disposition, since it is a contract which provides for a payment by the debtor. Further examples of transactions which have been held to be dispositions are the issuing of a check by the insolvent, both where his bank account is in credit and where he has been granted overdraft facilities. A contract between the insolvent and a party indebted to him in terms of which the latter is required to pay the amount of the debt to a creditor of the insolvent, and an arrangement by which a party who has agreed to lend money to the insolvent is required to pay the amount of the loan into the bank of a third person for the purpose of channeling the amount to a creditor of the insolvent. Number 4. The term disposition does not include a disposition made in compliance with an order of court. For example, the payment of a contractual debt or the delivery of property as ordered by the court. Even if the insolvent elected not to oppose the proceedings in question, or the order was obtained by agreement, that is, in terms of a consent paper. However, this exclusion does not apply, and therefore the disposition qualifies as a disposition for the purposes of the Act, if the creditor obtained the court order by fraud or by collusion with the insolvent and with the intention of prejudicing other creditors. The onus of proving fraud or collusion lies on the party seeking to set aside the disposition. Number 12.2. Dispositions which may be set aside. The dispositions which may be set aside are those: number 1, made not for value; number 2, having the effect of preferring one creditor above another, that is, voidable preferences; number 3, intended to prefer one creditor above another, that is, undue preferences; number 4, made in collusion with another person and having the effect of prejudicing creditors or preferring one above another; and lastly, made in fraudum creditorum, in fraud of creditors. The first 4 types are voidable in terms of the Insolvency Act, as per sections 26, 29, 30, and 31. The last, in fraud of creditors, may be set aside in terms of the common law. In practice, dispositions often fall into more than one category. Until a disposition is set aside by the court, it remains valid and binding. Only dispositions made by the insolvent are impeachable under the Act. Hence, a disposition made by the insolvent's bank without his authority does not qualify. Number 12.2.1. Disposition made not for value. Number 1. What must be proved? Section 26, subsection 1 empowers the court to set aside a disposition made for no value. The trustee must prove that the insolvent made the disposition when he made it and that he received no value for it. If the disposition was made more than 2 years before sequestration, the court can only set it aside if the trustee proves also that, immediately after it was made, the liabilities of the insolvent exceeded his assets, as per section 26, subsection 1a. If the disposition was made within 2 years of sequestration, the court must set it aside unless the person claiming under or benefited by it proves that, immediately after it was made, the assets of the insolvent exceeded his liabilities, as per section 26, subsection 1b. It is not necessary to establish whether or not the insolvent intended to prejudice creditors by making the disposition. The object of section 26 is simply to prevent a person in insolvent circumstances from impoverishing his estate by giving away assets without receiving any appreciable advantage in return. Value in section 26 means a benefit received or promised as a quid pro quo, either by the recipient of the disposition or by someone else. Examples of dispositions not for value are a donation and a payment for a promise which the promiser cannot be compelled to carry out. To qualify as value, the reciprocal benefit need not be monetary or tangible, not be a monetary or tangible one. In Commissioner for Inland Revenue versus Bowman NO 1990, the liquidator of a company sued to set aside payments by the company in respect of income tax as dispositions without value. The tax had been assessed on the basis of fictitious income and, in fact, no tax had been payable. The court rejected a suggestion that the services provided by the state with income tax revenue could be seen as a value for purposes of Section 26. Goldstone said, "The benefit which the taxpayer may enjoy from the manner in which the state spends revenue collected by the Commissioner appears too speculative and tenuous to be regarded as value within the meaning of Section 26, subsection 1. Payment of a lawful debt is not a payment without value, because the payer receives counter-value in the form of a discharge of his liability. Performance in terms of an illegal agreement can, it seems, qualify as value, provided the performance has actually been rendered. In each case, the question whether the insolvent has received value for his disposition must be decided by considering all the circumstances in which the transaction was made. The liabilities of the insolvent for purposes of Section 26 and also subsections 29 and 30 include any obligation undertaken as a surety, and the insolvent's assets must be taken to include any sum recoverable by way of a right of recourse after payment to the creditor. If it is proved that the liabilities of the insolvent at any time after making a gratuitous disposition exceeded his assets by less than the value of the property disposed of, the disposition may be set aside only to the extent of the excess, as per section 26, subsection 1. So, for example, if the insolvent made a gift of 5,000 Rand, which caused his liabilities to exceed his assets by 10,000 Rand, he may then acquire assets which reduced his margin of insolvency to 3,000 Rand. The disposition may be set aside only to the extent of 3,000 Rand. Number 2. Exception to section 26. Disposition in terms of ANC. A settlement of property in an antenuptial contract by the husband on his wife or any child to be born of the marriage is not liable to be set aside as a disposition without value on the husband's insolvency if certain requirements are met, as per section 27, subsection 1 and 2. Number 1. The disposition must be an immediate benefit, that is, a benefit given by a transfer, delivery, payment, cession, pledge, or a special mortgage of property completed within 3 months of the date of the marriage. Number 2. The disposition must have been given in good faith. Good faith in this context refers to the absence of any intention to prejudice creditors in obtaining payment of their claims or to prefer one creditor above another, as per section 2. And lastly, the antenuptial contract must have been duly registered at least 2 years before sequestration. Number 3. Beneficiary's right to share in estate limited. The beneficiary of a gratuitous disposition which has been set aside by the court has no right to claim in competition with the creditors of the insolvent estate, as per section 26, subsection 2. The same applies to the beneficiary of a gratuitous disposition which has not been set aside, but which was uncompleted by the insolvent. However, there is one exception to the latter rule. This where the uncompleted disposition was made by way of suretyship, guarantee, or indemnity. In this event, the promisee may compete with the creditors of the estate for an amount not exceeding the amount by which the value of the insolvent's assets exceeded his liabilities immediately before the disposition was made, as per section 26, subsection 2, proviso. This, for example, if the insolvent stood surety gratuitously for 5,000 Rand and immediately before entering into the contract, his assets exceeded his liabilities by 2,000 Rand, the creditor, in terms of the suretyship contract, may prove a claim for 2,000 Rand in competition with the insolvent's other creditors. If, immediately before contracting, the insolvent's assets were less than his liabilities, the suretyship creditor cannot prove in competition with other creditors. If, before contracting, the insolvent's assets exceeded his liabilities by 6,000 Rand, the suretyship creditor in the example may compete to the full extent of his claim of 5,000 Rand. Number 12.2.2. Disposition which prefers one creditor above another, that is, voidable preference. Number 1. What must be proved? In terms of section 29, subsection 1, the court may set aside a disposition made by the insolvent not more than 6 months before the sequestration of his estate or his death, where he is deceased and his estate is insolvent. If the disposition had the effect of preferring one of the insolvent's creditors above another and immediately after the disposition was made, the liabilities of the insolvent exceeded the value of his assets. The trustee has the onus of proving all these requirements. The policy behind section 29 is evidently that a person on the brink of insolvency should not be permitted to select one or a few of his creditors for full payment and disregard the rest. The disposition does not have to have been made directly to the creditor concerned. It must merely have had the effect of preferring him. This, where the insolvent, instead of paying C, his creditor, paid X, a creditor of C, the trustee can set aside the disposition to X on the ground that it had the effect of preferring C above the insolvent's other creditors. The test whether a creditor has been preferred is whether the proper distribution of the assets as envisaged by the Act has been defeated, or, in other words, whether the creditor has benefited more or been paid earlier than would have been the case if he had been paid a dividend in accordance with the Act. The claims proved against the estate are accepted as prima facie proof on the insolvent's liabilities as at the date of sequestration, and accordingly may be relevant for establishing the extent of the insolvent's liabilities immediately after disposition. The value of the assets to be assessed is the market value. This has been described inter alia as the full and fair price which the assets would be likely to realize if sold voluntarily under the usual terms and conditions, and the price which a willing seller might reasonably expect to obtain for the assets from a willing buyer. Number 2. Exception to Section 29. Disposition in the course of business and not intended to prefer. Section 29 enables the trustee to set aside transactions made and assets alienated by the insolvent while close to insolvency. The spectre of the trustee exercising his powers under Section 29 could be a superable obstacle for a business person who wishes to surmount his financial difficulties by carrying on business in the usual way. The legislature has accordingly included a proviso in Section 29 that the court cannot set aside a disposition if the person in whose favour it was made proves that it was made in the ordinary course of business and that it was not intended to prefer one creditor above another, as per Section 29, subsection 1. The beneficiary must prove both elements if the trustee's claim is to be defeated. Ordinary course of business. In deciding whether a disposition was made in the ordinary course of business, an objective test is applied. Whether the disposition was one which would normally be entered into between solvent business persons, or, stated differently, whether the disposition is in conformity with ordinary business methods adopted by solvent persons of business, or whether it would be anomalous, unbusinesslike, or surprising to the ordinary person of business. In Al-Qarafi and Sons versus Pema and others, NNO 2010, Milan remarked, as was said in Downs Distributing Company Proprietary Limited versus Associated Blue Star Stores Proprietary Limited, 1948. The expression in the ordinary course of business does suppose that according to the ordinary and common flow of transactions in affairs of business, there is a course, an ordinary course. It means that the transaction must fall into place as part of the undistinguished common flow of business done, so that it should form part of the ordinary course of business as carried on, calling for no remark and arising out of no special situation. The court must have regard to the terms of the disposition and the circumstances in which it was made, including the actions of the parties, but leave out of consideration the fact that the parties making the disposition was insolvent at the time. The court is concerned only with the disposition, not with the insolvent's business generally. A disposition may be made in the ordinary course of business if duly made in terms of a valid contract, even though the insolvent's overall business model is illegal and the payment is made with stolen money. An example of a disposition made in the ordinary course of business is afforded by Pretorius's trustee versus van Blomenstein, 1949. The insolvent bought a lorry and sometime later pledged it to secure payment of the price. He concluded the pledge because the seller had sued for the price and was only prepared to give an extension of time for payment if he received real security. The court held that, although it would not generally be in the ordinary course of business for a debtor to give a pledge for a debt which he had incurred earlier, here the insolvent had had little choice and had acted as an ordinary person of business would have done. Contrast Patterson N.O. versus Trust Bank of Africa Limited above. In this case, the insolvent, an attorney who had stolen from his trust account and badly needed to raise money, sold his legal practice to his professional assistant, C, for a cash sum of 15,000 rand, and further amounts to be paid later. The contract provided that the 15,000 rand should be paid into the insolvent's overdrawn business account with T Bank. This provision was inserted on the insistence of T Bank, which was prepared to grant C overdraft facilities for the 15,000 rand only if the money was applied to reduce the insolvent's overdraft. The court held that, although at face value the arrangement regarding how the 15,000 rand was to be paid was a normal banking transaction, when seen in the light of the circumstances, the arrangement fell outside the ordinary course of business. The contract between the insolvent and C had been in the nature of a forced sale, concluded because the insolvent had misappropriated money from his trust account, not an event in the ordinary course of business, and the insolvent had not been in a position to reject the condition imposed by the bank, which he would have been if the transaction had been concluded in the ordinary course of business. If the disposition was concluded in a specialized field of business, such as, for example, between brokers on the stock exchange, or between a bookmaker and his client in connection with the laying of bets, the court will take into account the customs which are shown to apply in that field of business. In Estate Wege versus Strauss, 1932, the insolvent paid a betting debt which had been outstanding for considerable length of time. The court took cognizance of the custom that betting debts must be paid immediately and held that the payment in question was not the ordinary course of business. To fall within the ordinary course of business, both the making and the receiving of the disposition must be lawful. Where, for example, a creditor receives usurious interest in terms of a contract of loan, the disposition is not in the ordinary course of business. No intention to prefer. The question of what is meant by intention to prefer is discussed below in number 12.2.3. Suffice it to say here that the insolvent will not be held to have intended to prefer it if it is established that, when he made the disposition, he did not contemplate or expect sequestration, or that his main purpose or dominant motive in making the disposition was something other than the conferring of an advantage on the creditor concerned, for example, to shield himself from a criminal prosecution or to cover up a misappropriation of assets and save himself from exposure, or to comply with a contractual obligation to give possession of his movable property to the creditor concerned for the perfecting of the latter's security under a general notarial covering bond. It has been held that proof that the insolvent entertained the hope of tiding over his financial difficulties is not per se sufficient to disprove the intention to prefer. Number 12.2.3. Disposition intended to prefer one creditor, that is, undue preference. Number 1. What must be proved? Under Section 30, the court may set aside a disposition which the insolvent made at any time before sequestration if he made the disposition with the intention of preferring one of his creditors above another, and when he made it, his liabilities exceeded his assets. The trustee has the onus of proving these elements. Once he has done so, judgment must be given in his favor. There are no defenses available to the person benefited by the disposition. The test for determining whether the insolvent had the intention to prefer is whether his dominant, operative, or effectual intention in making the disposition was to disturb the proper distribution of the assets on insolvency. The test is subjective. The question is not simply whether the insolvent should have known that the disposition would have the effect of conferring a preference, but whether, as a fact, he intended the disposition to have this effect, and whether this was his primary objective or main aim in making the disposition. It stands to reason that the insolvent must have applied his mind to the matter. If he did not actually consider whether he was conferring a preference, he cannot be said to have intended to do so. The following factors are relevant in determining whether the insolvent's dominant intention was to confer a preference. Number 1. Whether the insolvent contemplated insolvency when making the disposition. Contemplation of insolvency is generally necessary before an intention to prefer can be inferred, but it does not follow axiomatically from the fact that the insolvent contemplated sequestration that he had the intention to prefer. Other factors may negate this influence. The court will infer that the insolvent had the intention to prefer if it is established that he realized when making the disposition that sequestration was substantially inevitable. The insolvent in such a case is assumed to have intended the natural consequences of his act. Unless the evidence negates this inference and shows that his dominant intention was to achieve some purpose other than conferring an advantage on the creditor in question, for example, to protect himself from a criminal prosecution or to avoid exposure. Number 2. Whether the debtor was, at the time of the disposition, in a position to exercise a free choice. If the debtor paid the creditor under great pressure, for example, to avoid prosecution, an intention to prefer will not be proved. However, it is not any pressure or coercion that will displace the intention to prefer. Only pressure which is akin to duress or undue influence, or what has been described in the cases as an overwhelming sense of imminent peril, great pressure, or even severe or terrifying pressure. In Cooper and another N&O versus Merchant Trade Finance Limited, the court accepted that it does not follow, merely because the debtor received no consideration for the disposition or was not put under any pressure to make it, that the dominant intention was to prefer the other party. The presence of these factors may indicate conclusively that there was not a dominant intention to prefer, but the converse does not necessarily follow. One has to take all the circumstances into account and consider what is the correct inference to draw. And lastly, whether there is any relationship between the insolvent and the creditor, that is, in addition to that of a debtor and creditor. A close family relationship or friendship may motivate the insolvent to give preference, and therefore the presence of either is a factor to be taken into account in deciding whether there was an intention to prefer, but it is not conclusive of the issue. In deciding whether the insolvent had the intention to prefer, the court must weigh up all the relevant facts that prevailed at the time of the disposition and decide the issue on a balance of probabilities. If the facts permit of more than one inference, the court must select the most plausible or probable inference. If this favors the trustee, he is entitled to judgment. If, on the other hand, an inference in favor of both parties is equally possible, the trustee will not have discharged the onus resting on him. The fact that the insolvent does not give evidence does not ipso facto mean that one must infer that there was an intention to prefer. Number 2. Differences between trustees' powers under Section 30 and Section 29. It will be observed that the trustees' powers under Section 30, that is, undue preference, differ significantly from his powers in terms of Section 29, that is, voidable preference. Number 1. An undue preference may be set aside irrespective of when before sequestration it was made, whereas a voidable preference can only be set aside if it is made not more than 6 months before sequestration or the insolvent's death, as the case may be. Number 2. For a disposition to be an undue preference, the debtor must actually be the insolvent when he makes it. A disposition may qualify as a voidable preference even if the debtor is solvent when he makes it, provided he is insolvent immediately thereafter. Number 3. To have a disposition set aside as an undue preference, the trustee must prove that the debtor actually intended to prefer one creditor above the others. On the other hand, the trustee may establish a voidable preference by showing merely that the disposition had the effect of preferring one creditor above another. And lastly, Section 30 does not grant a defense to the beneficiary of an undue preference, whereas Section 29 does, to the beneficiary of a voidable preference. Number 12.2.4. Collusive disposition which prejudices creditors or prefers one creditor. Section 31, subsection 1 provides that the court may set aside a transaction entered into by the debtor before sequestration, in terms of which he, in collusion with another person, disposed of his property in a manner which had the effect of prejudicing his creditors or of preferring one of these creditors above another. The element of collusion distinguishes this type of disposition from voidable and undue preferences. Collusion in this context is an agreement with a fraudulent purpose, not merely an agreement with the result that one creditor is preferred above another. To succeed with an action under Section 31, subsection 1, the trustee must prove the following. Number 1. The insolvent made a disposition of his property. Number 2. The disposition was made in collusion with another person. That is to say, the insolvent and the other person both knew that the former was insolvent and expected the disposition to have the effect of prejudicing creditors or of preferring one above another. Number 3. The disposition had the effect of prejudicing creditors or preferring one above another. In addition to setting aside the collusive disposition, the trustee may recover from any person who was a party to the disposition, firstly, any loss which the disposition caused to the insolvent estate, and secondly, a penalty in an amount determined by the court but not exceeding the amount by which the party concerned would have been benefited by the disposition if it had not been set aside, as per Section 31, subsection 2. The compensation and penalty may be recovered in the action to set aside the disposition, as per Section 31, subsection 3. If the other party to a collusive disposition is a creditor, he forfeits any claim that he may have had against the estate. Number 12.2.5. Disposition in fraud of creditors. The action Poliana. Although the Act sets out specific circumstances in which disposition of the insolvent's property may be set aside, it does not deprive creditors of their right under the common law to have a disposition set aside as being in fraudem creditorum. The relevant action at common law is known as the action Poliana. To succeed in bringing the action Poliana, the plaintiff must prove that, number 1, the action diminished the debtor's assets. Number 2, the person who received from the debtor did not receive his own property. And number 3, there was an intention to defraud. And lastly, the fraud took effect. The term fraud in this context does not have its criminal law connotation. The test is simply whether the object of the transaction was to give another creditor an unfair advantage over the others in insolvency. In the case of a disposition for value, that is, one made ex tituluneroso, it must be shown both that the insolvent intended to commit a fraud on his creditors and that the recipient of the disposition knew of his intention and was privy to it. In the case of a gratuitous disposition, it is sufficient to prove fraud on the part of the insolvent alone. The bona fide or otherwise of the recipient is irrelevant. Creditors may invoke the action Poliana to recover not only the assets disposed of, but also any benefits accruing from the insolvent's fraud. The latter benefits include the proceeds of trading with the alienated assets as well as any property acquired therewith, or its value or the proceeds thereof. Number 12.3.1. Who may sue? Proceedings to set aside a disposition rendered impeachable by the Act or to recover compensation or penalty payable under the Act may be instituted by the trustee, as per Section 32, subsection 1. If the trustee fails to bring the proceedings, a creditor or creditors may sue in the trustee's name, provided he indemnifies the trustee against all costs, as per Section 32, subsection 1. The indemnity is necessary to protect the estate against any adverse costs order that the creditor may incur, the trustee being liable as nominal plaintiff for such costs. Consequently, the indemnity must be given before the action is instituted and must be adequate for the purposes of the proceedings. In addition, the creditor must be able to meet his obligations under it within a reasonable time after being called upon to do so by the trustee. In Lane's case, the court accepted that a creditor may sue to avoid a disposition where only a provisional trustee has been appointed, and the latter has failed to obtain leave from the court to sue in terms of Section 18, subsection 3. The court held, differing from an earlier decision in Lane N.O. and another versus Harkson and others, 1998, that the creditor need not obtain leave of the court since he is obliged to provide an indemnity in terms of Section 32, subsection 1, and this protects creditors of the estate. In the Western Flyer case, the court explained that although the institution of proceedings without first providing an indemnity constitutes an irregularity, it does not necessarily invalidate the proceedings. The purpose of the legislature, as expressed in Section 32 of the Act, is to provide that in the event of a creditor instituting action in the name of the trustee should be safeguarded by the indemnity against all costs of the litigation. The purpose of the section is not to regulate principles relating to locus standi or the validity of the manner by which the action is to be instituted. For that reason, the indemnity must be provided before the action is instituted, that is, before any costs have been incurred. However, it is provided after the action has been instituted in such a manner that the trustee is not at risk as far as costs, both before and after the indemnity are concerned. The purpose of Section 32 has been achieved. Where a creditor institutes action in the trustee's name, he is obliged to cite the trustee as plaintiff, that is, nominal plaintiff, in the proceedings. It is not competent for him to sue in his own name and merely allege that he sues in the name of the trustee. No other creditor is entitled to derive any benefit from monies or property recovered in the action until the claim and costs of the litigating creditor have been paid in full, as per Section 104, subsection 3. Moreover, any creditor who was aware that the proceedings had been instituted and who delayed in proving his claim until the court had given judgment is not entitled to share in any money or the proceeds of any property recovered as a result of the proceedings, as per Section 104, subsection 2. The trustee is also the proper person to institute the action Puliana at common law. The court may, on application, allow a creditor to sue in his own name, provided he joins the trustee as a party to the suit, either as a co-plaintiff if he is willing, or as a co-defendant if he is unwilling. Number 12.3.2. Jurisdiction of the court. Proceedings to set aside an impeachable disposition may be brought in the magistrate's court, provided the matter falls within the normal jurisdictional limits of that court, as per Section 2, see the definition of court. Number 12.3.3. Time for bringing proceedings. The trustee's power to bring proceedings to set aside improper transaction in terms of Section 32, subsection 1 is not subject to any time constraints. He, or failing him, a creditor, may institute proceedings even after confirmation of the liquidation and distribution account. Confirmation of an account in terms of Section 112, in other words, has no bearing at all on a claim in terms of Section 32. Number 12.3.4. Interim relief. If the subject matter of an impeachable disposition is in the possession of the creditor, the trustee may apply to court for an attachment of the property concerned, pending the determination of proceedings to set aside the disposition. The trustee need only make out a prima facie case that he is entitled to reclaim the property for the estate. He does not have to show that the estate will suffer irreparable loss if the attachment is not granted. The requirement of suing in the name of the trustee does not necessarily apply to interim proceedings. These may be instituted by a creditor in his own name if the situation requires swift action to protect a right, especially one that is vindicatory or quasi-vindicatory. Number 12.3.5. Evidence. Section 32, subsection 2 provides that any party to proceedings to set aside an improper disposition may subpoena the insolvent to give evidence, and the court may also call upon him to do so. The section goes on to state that, when giving evidence, the insolvent may not decline to answer a question on the ground that the answer may tend to incriminate him or may prejudice him in criminal proceedings, which are to be brought against him. In the light of Parbu and others versus Gates N.O. and another 1997, it seems clear that this latter provision offends against the constitutional right against self-incrimination, that is, Section 35 of the Constitution of the Republic of South Africa, and is invalid insofar as it permits the use of incriminating evidence in criminal proceedings, except proceedings dealing with perjury or unrelated offences. In Parbu, the Constitutional Court declared invalid Section 415, subsection 5 of the Companies Act 61 of 1973, dealing with the admissibility of evidence obtained at an inquiry in terms of Section 415, subsection 1 of the Act, to the extent that the section provided for the admission of incriminating evidence in criminal proceedings, other than for perjury or related offences. Where a creditor has instituted proceedings in the trustee's name, the creditor is not entitled to make discovery under the uniform rules of court. Only the trustee can do so. Number 12.3.6. Prescription of claim. In Bernard and Lynn, NNO versus Skuman and another, 2000, it was held that a claim to set aside an impeachable disposition in casu avoidable preference does not become a debt for purposes of prescription, and hence prescription in respect of the claim does not begin to run until the court has determined the value of the claim and pronounced upon it, after considering any possible defences available to the debtor. This view was rejected in Duet and Magnum Financial Services, CC, in liquidation versus Koster, 2010. The court accepted that Sections 26 to 31 and Section 32, subsection 3 of the Insolvency Act give to the trustee, the liquidator, a right in prescribed circumstances to have a person declared to be a debtor of the estate, and the complement of this right qualifies as a debt for purposes of prescription. The court held further that prescription of the debt ordinarily commences to run no later than the date upon which the trustee, liquidator, is appointed. Number 12.4. Order setting aside disposition. Number 12.4.1. Recovery of any property alienated. When setting aside disposition, the court must declare the trustee entitled to recover any property alienated under the disposition, as per Section 32, subsection 3. If it is impossible for the third party to return the property, for instance, because it has been destroyed or transferred to another person, the court must declare the trustee entitled to recover the value of the property, that is, the value at the date of the disposition, or at the date on which the disposition is set aside, whichever is the higher. Number 12.4.2. Execution on court's judgment. Once judgment is granted in favor of the trustee, he is in the same position as any other judgment creditor and may have recourse to the ordinary methods and processes of execution, should the defendant not obey the order of his own accord. Mora interest is payable by the defendant from the date of the judgment setting aside the disposition. If the defendant's estate is under sequestration, the trustee is not entitled to obtain payment of the full amount of the judgment debt, but is merely entitled to prove as a concurrent creditor in the estate. Number 12.4.3. Indemnity to bona fide recipient of disposition. Under Section 33, subsection 1, the recipient of a voidable disposition who in good faith parted with property or security or lost a right against another person is not obliged to comply with an order to restore the subject matter of the disposition, unless the trustee has indemnified him for parting with the property or security or for losing the right. The recipient must prove in particular the following requirements, the onus being on him to do so. Number 1, that in return for the disposition, he parted with property or security which he held or lost a right against another person. The words in return for indicate that there must be reciprocity between the disposition and the passing of the property or loss of the right. In other words, the latter must be a quid pro quo for the former. Section 33, subsection 1 is not applicable if the recipient neither parted with property nor given up any right in return for the disposition, or if there is merely an incidental connection between them. In the Barclays Bank case, the insolvent, a company, had given a suretyship undertaking to B Bank and passed a bond in favor of the bank to secure payment in terms of the suretyship undertaking. The bank contended that, in return for these dispositions, it had parted with sums of money, viz. Amounts lent to the principal debtor on overdraft after signature of the deed of suretyship, and that it was not obliged to restore the benefit it had obtained under the dispositions unless the liquidator indemnified it for the loans in question, which the liquidator had not done. The court held that the loans were not the consideration or the quid pro quo for the suretyship undertaking and bond. The loans had been given in terms of an agreement between the bank and the principal debtor, and if they had been made in return for anything, it was the undertaking by the principal debtor to pay interest on the overdraft. It followed that the bank's contention could not be sustained. In the Consolidated News Agency's case, the court observed that where the respective acts of the parties are said to have arisen from the agreements between them, an examination of the terms of the agreement is the first step in determining whether the necessary reciprocity is established. Number 2, that he acted in good faith. The requirement of good faith applies to all the circumstances surrounding the transaction. It is not confined to the conduct that gave rise to the property or security being parted with or the rights being lost. The creditor must show inter alia that at the time of the transaction, when he parted with the property or gave up the rights, he did not know or contemplate that the debtor was insolvent or on the brink of insolvency. The underlying purpose of Section 33, subsection 1 is to ensure that when a disposition is set aside in terms of the Act, there is restitutio in integrum. That is, the restoration of both parties to their positions before the disposition was made. Proof of the above requirements does not affect the right of the trustee to have the disposition set aside, but the trustee cannot insist on compliance with the court's order for return of the property or benefit disposed of until he has given an indemnity to the recipient. Number 12.4.4. Effect of order on underlying debt. It is not entirely clear whether an order setting aside a disposition always extinguishes the debts between the parties. The issue is important not only for the beneficiary of the disposition, who may wish to claim against the insolvent estate, but also for a surety for the debtor, since a surety is discharged if the principal obligation is extinguished for any reason. The courts appear to have accepted that an order setting aside a gratuitous disposition in terms of Section 26 invalidates the debt between the parties, and hence precludes any claim by the beneficiary and discharges any surety. But there are no conflicting decisions on whether an order setting aside a voidable preference under Section 29 has the same effect. In Friedman and Rossi Proprietary Limited versus Gaustein and others 1986, it was held that the order vitiates the debt, but in Mulman N.O. and Stein N.O. versus Kampfer 1993, the court held that it merely prohibits the unusual prejudicial performance of the debt and does not extinguish it. According to this view, the beneficiary may claim against the estate, and a surety for the insolvent remains liable. The courts have not yet spelled out the consequences of an order setting aside a disposition in terms of Section 30, that is, undue preference, or one in terms of Section 31, that is, collusive disposition. For the beneficiary of the latter, however, the issue is of academic interest, since Section 31, subsection 2 provides that if the other party to a collusive disposition is a creditor, he forfeits any claim which he may have had against the estate. It remains to be seen which approach will find favour with the Supreme Court of Appeal. Clearly, the same principle should apply irrespective of whether the disposition before the court is set aside in terms of Section 26 or Section 29, or for that matter, any other section. Number 12.5. Exemption of certain dispositions from Act. In certain instances, the provisions of the Act governing dispositions do not apply. Number 1. Sections 26, 29, and 30. Dispositions without value, voidable preferences, and undue preferences do not apply to property disposed of in accordance with rules of an exchange. That is, per Section 35A, subsection 5, or property disposed of in that is, per Section 35B, subsection 4. Number 2. Section 35, subsection 2A of the Prevention of Organized Crime Act 121 of 1998 provides that if the estate of a defendant who was made an affected gift to another person is sequestrated, a court must not set aside the disposition of that gift under Section 29, 30, or 31 of the Insolvency Act if a prosecution for an offence has been instituted against the defendant and the proceedings against him or her have not been concluded, or if that other person's property is subject to a restraint order. If a court does not set aside a disposition contemplated under Section 35, subsection 2A, after proceedings against the defendant have been concluded, it must take into account any realization of the property of the other person under Chapter 5 of the Act, as per Section 35, subsection 2B. Number 12.6. Transfer of business without prescribed notice. In terms of Section 34, subsection 1 of the Insolvency Act, if a trader, without giving notice as prescribed by the Act, transfers in terms of a contract a business belonging to him or its goodwill, or any goods or property forming part of it, except in the ordinary course of that business or for securing the payment of a debt, the transfer is void as against his creditors for 6 months thereafter, and it is void against his trustee if his estate is sequestrated at any time within that period. Transfer for these purposes includes the transfer of possession, actual or constructive. The trader does not actually have to transfer ownership to the other party, as per Section 34, subsection 4. Section 34, subsection 1 is applicable irrespective of the manner in which the transfer takes place or the nature of the preceding agreement. The notice referred to its publication of a notice of intended transfer in the Government Gazette and 2 issues of an Afrikaans newspaper and 2 issues of an English newspaper circulating in the district in which that business is carried on, as per section 34 subsection 1. The publication must appear not less than 30 days and not more than 60 days before the date of the transfer. It must provide accurate information regarding the transfer. If, for example, it states the wrong date, it is invalid. Publication of the notice is required even if the trader's creditors know about the intended transfer. As soon as notice is published in terms of section 34 subsection 1, every liquidated liability of the trader in connection with his business which would become due at some future date falls due immediately, if the creditor concerned demands payment, as per section 34 subsection 2. The following should be noted with regard to the scope and effect of section 34 subsection 1. Number 1. The section is designed to protect the creditors of a business. It is aimed at the all too common practice whereby a trader seeks to evade his business debts by disposing of the business to a third party who is not liable for its debts and thereafter dissipating the price or using it to pay some creditors, regardless of the claims of others. This section applies whether or not the trader's estate is sequestrated, and even if the disposal was an advantageous one, for example, at a price in excess of the value of the assets in question, because creditors may be prejudiced even where the business or its assets are advantageously disposed of. Number 2. The section applies only to traders. A trader, in terms of section 2, is a person who carries on a trade, business, industry, or undertaking of a kind specified in the section. The specified activities cover a wide field and include any business in which property is sold or is bought, exchanged, or manufactured for purpose of sale or exchange. Certain activities are not covered, for example, letting and hiring of immovable property, and transport haulage. The test in each case is whether the person concerned carries on the relevant activity as part of his core business. The definition is not applicable if the activity is merely incidental to the primary business activities of the enterprise. The definition says that a person is deemed to be a trader until proved otherwise. So a person alleged to be a trader bears the onus of proving that his primary business activity falls outside the ambit of the definition. A person does not cease to be a trader for these purposes simply because he ceases to operate his business, closes his doors. He remains a trader and continues to be subject to section 34 subsection 1 for as long as he owns the business or its assets and owes debts in respect thereof. So, for example, the section is applicable where a trader alienates the assets of his business 4 weeks after he has ceased to trade. 4 weeks after he has ceased to trade. Number 3. The section applies to the transfer of part of a business, in particular the transfer of the goodwill of the business, or goods or property forming part of the business. In Unisa versus Ensor NO above, it was held that, having regard to the purpose of section 34 subsection 1, it would be undesirable to lay down any definite criterion for determining when goods form part of a business. However, any goods purchased and received by a trader ostensibly for his business must be regarded as forming part of the business, irrespective of whether the goods have been physically appropriated to its stock in trade. In the court's view, if the position were otherwise, the purpose of the section could be easily defeated. Number 4. The section does not apply to the transfer of goods or property of a business if the transfer is in the ordinary course of that business. The word "that" is important. The inquiry is not whether the transaction would normally have been entered into by the solvent business's persons, but whether it would normally have been concluded by a solvent person conducting a business of the kind carried on by the debtor. Regard must be had to what is or would be done by similar businesses in similar circumstances. In this case, M, which carried on business inter alia as a dealer in Mazda vehicles and spare parts under franchise from I, sold its entire stock of Mazda parts to I. The sale came about because I had terminated the franchise agreement between the parties and had exercised an option in the agreement which allowed it, on termination of the franchise, to purchase all unsold Mazda parts held by M. The court held that although the sale by a motor dealer of his stock of spare parts at one and the same time would not normally be in the ordinary course of that business, in casu the position was different because M had been bound to sell in terms of the franchise agreement. This agreement had been entered into in the ordinary course of M's business, and its terms had been part and parcel of the business. In submitting to I's exercise of its rights under the agreement, M had acted as any solvent business person carrying on that type of business would have done. Trollope observed, "It must necessarily be a paramount principle of carrying on business that a solvent trader should duly honour his obligations under a contract entered into in the ordinary course of his business." Sorry, these facts pertain to the case of Enzor N.O. versus Rensko Motors Proprietary Limited, 1981. Contrast Gore and another NNO versus Safficon Industrial Proprietary Limited, 1994, and Gainsford and others NNO versus Tifsky Property Investments Proprietary Limited and others above, and Ruis N.O. in a ander versus Kevin in Losia Property Investments BK en andere, 2002. In Gore's case, is a company in the business of selling and servicing forklifts sold 90% of its assets in the hope of staving off liquidation of the group of companies of which it was part. It was held that merely because the sale fell within the ordinary course of business of the group companies as a whole, as what was alleged, it did not mean that it was within the ordinary course of S's business. S was in the business of providing forklifts, and the sale did not fit into the ordinary course of that business. Similarly, in Gainsford's case, a company used its immovable and movable property to run a ski resort business. The court held that the company's disposal of all this property could, by no stretch of the imagination, fall within the ordinary scope of its business. In Ruis, a company earning income from the letting of shops and flats on its immovable property had two creditors, one of which a bank holding 3 mortgage bonds over the immovable property. To discharge its indebtedness to the bank, the company sold its entire business, including the movable property, subject to the condition that the buyer registered a bond in favor of the bank in the same amount as the company's indebtedness to the bank. The transfer of the property left the company an empty shell, unable to pay its other creditors. The court held that, since the transfer had effectively rendered the company incapable of carrying on its business of generating income through property letting, it had not been concluded in the ordinary course of the business of the company. Number 5. The section is also inapplicable where the transfer is to secure the payment of a debt. So, for example, the section does not apply to the pledge of a movable. Number 6. Where the trustee alleges that a transfer of goods falls within the section, he bears the onus of proving that, first, the goods formed part of the insolvent's business at the time of the transfer. It does not suffice for him to show, for example, that they form part of the insolvent's assets generally, and secondly, the transfer was not in the ordinary course of the insolvent's business. Number 7. A transfer which has not been advertised is void as against the trustee. It follows that the trustee need not bring an action to have the transfer set aside. He may simply disregard it and demand return of whatever assets have been delivered to the transferee. However, if the transferee resists, the trustee will effectively be compelled to ask the court for an order declaring the transfer void and requiring the transferee to hand over all the assets in his possession which originally belonged to the business. If the transferee has already resold the assets and can no longer restore them to the trustee, the latter may be sued for their value by bringing a delictual action for wrongful disposal. Once the transferee has returned the assets or their value to the trustee, he has a concurrent claim against the estate for the amount that he paid or for the other performance that he rendered to the insolvent. Number 8. An unadvertised transfer is not void in any absolute sense, only against the trustee. This means that it is within the discretion of the trustee to treat the transfer as void or not. The trustee may always waive or choose not to exercise his powers under the section, and if he does this, the transfer remains standing. The trustee will generally elect to abide by the transfer if the assets have depreciated since the conclusion of the sale, and he will find it difficult to match the price agreed upon, or if the price fixed still exceeds the market value of the assets. A decision by the trustee to treat the transfer as void invalidates any mortgage bond that the transferee has registered over the immovable property of the business. The reason is that a transfer in contravention of Section 34 is void ab initio, and accordingly the transferee does not acquire ownership of the immovable property and cannot encumber it with a mortgage bond. The mortgagee is not arbitrarily deprived of property as envisaged by Section 25, subsection 1 of the Constitution. Inter alia, because there is a rational connection between the voidness of a transfer hit by Section 34, subsection 1, and the ends sought to be achieved to protect the creditors of a trader who transfers his business at a time when he is in financial difficulties. Number 12.7. Transfer of business after proceedings instituted. Section 34, subsection 3 deals with the situation where a trader transfers his business after another person has instituted proceedings against him for the purposes of enforcing a claim against him in connection with the business. The section renders the transfer void as against the person concerned for the purpose of such enforcement if either, number 1, the transferee is aware at the time of transfer that the proceedings have been instituted, or number 2, the proceedings have been instituted in a high court or the magistrate's court having jurisdiction in the district in which the business is carried on. The following should be noted in regard to Section 34, subsection 3. Number 1. The section applies irrespective of whether the trader gives notice of the transfer of business as prescribed by Section 34, subsection 1. Number 2. The creditor is protected if he has instituted proceedings prior to the transfer. He need not have taken judgment. Number 3. The protection afforded by the section is not limited as to time. Number 4. For the section to apply, the claim sought to be enforced must be one in connection with the business. A claim to enforce a liability of the trader unrelated to the business does not enjoy the protection of the section. In Simon versus DCU Holdings Proprietary Limited and others above, it was held that the phrase "in connection with the business" must not be interpreted in a narrow or technical way, and that it is wide enough to include a claim for the balance of the price of all the assets of the business. And number 5, the creditor is not denied the protection of the section where the agreement on which his claim is based has been amended or superseded by another agreement, provided there is a sufficiently close connection between the proceedings and the second agreement. In Weltman's Custom Office Furniture Proprietary Limited in liquidation versus Whistler CC above, the agreement of sale originally sued upon had been replaced by a settlement agreement. It was held that this agreement was sufficiently closely connected to the proceedings for the section to apply. Malinsky explained, the compromise did not exchange the essential nature of the creditor's claim. Both the original and the settlement agreements related to the sale of the same business and the creditor's claim. Under each agreement was for payment of the purchase price. The compromise differed from the original agreement in relation to the amount payable and the method of payment, but it did not alter the essence of the creditor's claim or the debtor's obligation. The result is that the proceedings instituted by the creditor before the transfer are sufficiently closely connected to its claim under the settlement agreement to entitle this court to hold the transfer to be void for the purposes of Section 34, subsection 3. And lastly, the section does not render the transfer of the business completely void, but only void as against the creditor who has instituted proceedings and to the extent of his claim. MRL3701, Hockly's Insolvency Law, Chapter 13. Interrogation of the insolvent and other witnesses. Introduction. To enable the trustee and creditors to investigate the insolvent's affairs and ascertain his true financial position, the Act provides for the interrogation of the insolvent and other witnesses. The Act also empowers the master to conduct a private interrogation. These matters are considered in this chapter. If the trustee merely holds informal discussions to investigate matters which clearly call for a formal interrogation, he is guilty of a dereliction of duty and may have his remuneration reduced or disallowed by the master in terms of Section 63, subsection 1. Number 13.1. Interrogation by trustee or creditor or presiding officer. Number 13.1.1. When and where interrogation may take place. An interrogation may be conducted at any meeting of creditors, as per Section 65, subsection 1. It may take place, for instance, at a special meeting called for the purpose of proof of claims, or at a general meeting convened for the purpose of giving the trustee directions concerning matters relating to the administration of the estate. The meeting must be properly called. If it is not, the interrogation cannot proceed. In Aesop versus the Master and another above, the trustee called a general meeting for the purpose of interrogation of witnesses. It was held that, in terms of Section 41, a general meeting had to be convened by the trustee for the purpose of giving him directions concerning any matter relating to the administration of the estate, and that it was not competent to call the meeting solely for the purpose of interrogating witnesses. Accordingly, a subpoena requiring a witness to attend the meeting for interrogation had to be set aside. Again, in Markey and another versus De Villiers and another, NNO 1990, the trustee called a special meeting for the further proof of claims, but his sole purpose in convening the meeting was to interrogate the insolvent and other witnesses. The court held that the meeting had not been properly convened and hence the interrogation could not proceed. Number 13.1.2. Who may be interrogated? The person who may be interrogated are the insolvent, and any other person present at the meeting who has been, or who might have been, summoned to appear for interrogation in terms of Section 64, subsection 2. In terms of Section 64, subsection 2, the presiding officer at any meeting of creditors may summon any of the following persons to appear at the meeting for the purpose of being interrogated. Number 1. Any person who is known or on reasonable grounds believed to possess or to have been in possession of property which belonged to the insolvent prior to sequestration of his estate, or which belongs or belonged to the insolvent estate or to the insolvent's spouse. Number 2. Any person who is known or on reasonable grounds believed to be indebted to the estate. And number 3. Any person who, in the opinion of the presiding officer, may be able to give material information concerning the insolvent or his affairs, whether before or after sequestration. Any property belonging to the estate or the business, affairs, or property of the insolvent spouse. The presiding officer may also summon any person who is known or on reasonable grounds believed to possess any book or document containing information referred to in section 64 subsection 2, to produce the book or document or an extract from it at a meeting of creditors, as per section 64 subsection 3. A person subpoenaed to produce documentation of a certain clause in terms of this section must actually produce it. It is no answer for him to say simply that the trustee may have access to everything that he, the witness, has. It will be observed that the range of witnesses who may be summoned to appear and the documentary evidence that may be called for is extensive. The reason is evidently to allow the trustee and creditors to investigate the affairs of the insolvent on the widest possible basis. Although a subpoena in terms of section 64 subsection 2 may be couched in wide terms, it must be limited to what is a permissible investigation under the section. The insolvent is obliged to attend the first and second meetings of creditors, including any adjournments, unless he has obtained the written permission of the presiding officer to absent himself, as per section 64 subsection 1. This permission may only be granted after consultation with the trustee. The insolvent must also attend a general or special meeting if required to do so by written notice of the trustee. If the insolvent or his spouse is called upon to attend a general or special meeting of creditors, he or she is entitled to an allowance out of the estate to defray necessary expenses incurred in connection with the attendance, as per section 65 subsection 8. Any other person summoned to attend a meeting for the purpose of interrogation is entitled to be paid out of the estate the fees to which he would be entitled if he were a witness in civil proceedings in a court of law, as per section 65 subsection 7. Number 13.1.3. Who may interrogate? The interrogation may be conducted by the trustee, any creditor who has proved a claim against the estate, the presiding officer, or the agent of any of these parties, as per section 65 subsection 1. Number 13.1.4. Subject matter of interrogation. Section 65 subsection 1 provides that the insolvent or a witness may be interrogated concerning: number 1. All matters relating to the insolvent or his business or affairs, whether before or after the sequestration of his estate. Number 2. Any property belonging to the estate. And number 3. The business, affairs, or property of the solvent spouse, as per section 65 subsection 1. It will be noted that the scope of the interrogation, like the presiding officer's powers to summon witnesses, is defined in the widest terms. This is necessary if the interrogation is to achieve its object, viz. Obtaining a complete and detailed picture of the insolvent's estate and financial affairs. It follows that it is permissible and not an abuse of the process to hold an interrogation for the purpose of gathering information for possible civil litigation against parties with whom the insolvent was connected or had dealings. In Harkson v. Lane, N.O. and others, 1998, it was argued that section 65 subsection 1 amounted to an unconstitutional violation of the solvent spouse's fundamental rights enshrined in the interim Constitution of the Republic of South Africa 200 of 1993. In particular, her rights under the equality and property clauses and her rights to privacy and freedom and security of the person. The court did not agree. Its reasoning appears from the following passage. On the basis that it is constitutional to vest the property of a solvent spouse temporarily in the master or trustee, it follows that the solvent spouse similarly can have no legitimate complaint to being interrogated concerning her or his own property and affairs to the extent that they are relevant to the insolvent estate. As far as reliance is placed upon subsection 11, subsection 1, and section 13 of the interim constitution, that is, the clauses dealing with privacy and freedom and security of the person, it is necessary to have regard to the scope of questions which a person summoned is required to answer. The first limitation relates to their relevance to the purpose of the meeting. The purpose is clearly the affairs of the insolvent estate. It follows that to the extent that the person may be required to answer questions concerning the business, affairs, or property of the solvent spouse, the information sought must be relevant to the estate of the insolvent spouse. A second and even wider limitation is to be found in the provisions of Section 139, read with Section 66, subsection 3 of the Act. A presiding officer may not commit to prison a person who refuses to answer a question not lawfully put to him. A question which would constitute an invasion of a constitutional right of an examinee cannot be said to be one lawfully put. To paraphrase these words, Ackerman in Nell versus LaRue, N.O. and others, 1966, if a presiding officer at a meeting of creditors held under the Act finds that in answering any question, the examinee's rights under Chapter 3 of the Interim Constitution would be infringed, he or she should hold that this did not constitute a question lawfully put to the examinee and that a refusal to answer such a question did not therefore constitute conduct punishable by imprisonment under Section 66, subsection 3, and therefore would not constitute an offence under Section 139, subsection 1. Number 13.1.5. Procedure at interrogation. The presiding officer must call and administer the oath to the insolvent or other witnesses who may then be interrogated, as per Section 65, subsection 1. There are no issues formulated beforehand. The inquiry is conducted for the purpose of discovery to obtain facts that the trustee and creditors do not possess and which may be of financial benefit to the estate. The statement of any person being interrogated must be recorded in the same way as evidence in a civil court, as per Section 65, subsection 3. Where the insolvent is interrogated, he must be required to make a declaration that he has made a full and true disclosure of all his affairs, as per Section 65, subsection 4. The presiding officer must ensure that the proceedings are conducted in accordance with the fundamental principles of justice and must ensure that he performs his functions fairly and impartially. The court may intervene to stop an interrogation if it amounts to an abuse of Section 65, or if it is vexatious or oppressive. The presiding officer must disallow any question which is irrelevant and may disallow a question which would prolong the interrogation unnecessarily, as per Section 65, subsection 1. It has been held that he should exclude questions on the latter basis if they are not calculated to produce material information about the insolvent's affairs or if the information can be obtained more readily from another source. Questions to establish the general credibility of a witness are permissible, provided they are relevant to the affairs of the insolvent. Questions which infringe a witness's constitutional rights are not lawfully put, and he need not answer them. The fact that the presiding officer is obliged in certain circumstances to hold the inquiry in camera does not mean that in all other circumstances it must take place in public. A person called upon to give evidence may be assisted at his interrogation by an advocate, attorney, or other agent, as per Section 65, subsection 6, and is entitled to be informed of his right to such assistance. However, he has no constitutional or other right of access to information prior to the inquiry. He is called to the inquiry to assist in providing information, not to receive it. A witness may be interrogated even though he is a witness in a pending civil trial concerning the subject of the proposed interrogation. Number 13.1.6. Privilege. In general, the law relating to privilege applies in connection with the giving of evidence or the production of a book or document at an interrogation, as per section 65, subsection 2. However, the principles of privilege are relaxed to some extent, to allow an interrogation to achieve its intended purpose. The Act lays down the following provisions in this regard. First, a person being interrogated may not refuse to answer a question on the ground that the answer would tend to incriminate him, or on the ground that he is to be tried on a criminal charge and may be prejudiced at such trial by his answer, as per section 65, subsection 2. Secondly, a banker of the insolvent or his spouse must, if summoned to do so, produce all checks in his possession which are drawn by the insolvent or his spouse within 1 year of sequestration. If a check is not available, the banker must produce any record which he has of the payment. If called upon to do so, the banker must give any information which he has regarding the missing check, or the bank account of the insolvent or his spouse. And lastly, any evidence given at an interrogation is admissible in any proceedings instituted against the person who gave the evidence, as per section 65, subsection 5. Section 65, subsection 2a limits the ambit of the above provisions in two respects. A presiding officer must hold the incriminating or prejudicial part of any proceedings in camera and prohibit the publication of any incriminating evidence, as per section 65, subsection 2a. And no incriminating evidence given at an inquiry may be admitted in any criminal proceedings, except in proceedings for perjury or related offences, as per section 65, subsection 2a(b). The expression part of the proceedings in this context is not confined to specified or determinable questions and answers. The overall effect of the provisions is that an examinee cannot refuse to answer incriminating questions, and that the answers he gives may be used against him in civil proceedings and in criminal proceedings relating to perjury and related offences, but not in criminal proceedings generally. The rationale here is not difficult to discern. The purpose of an interrogation is to obtain information about the insolvent estate which would not otherwise be disclosed to the trustee or to creditors, and which may be used to recoup money or property for the benefit of the estate. To achieve this purpose, it is essential that the trustee and creditors be permitted to ascertain whether the insolvent or any other person has acted improperly or in fraud of creditors of the estate. This task would be impossible if the examinee could decline to answer questions on the basis that they might incriminate him, and if the evidence elicited at the interrogation could not be used in subsequent civil proceedings against the examinee. The Companies Act No. 61 of 1973 contains a provision similar, although not identical, to Section 65, that is, Section 415. Section 415, subsection 5, states that any evidence given at an interrogation in terms of Section 415, subsection 1 of the Act is admissible in any proceedings instituted against the person who gave the evidence. This section, therefore, allows for incriminating evidence given at such an interrogation to be admitted in any criminal proceedings against the person concerned. In Porbu and others versus Gates, N.O. and another, 1997, it was held that Section 415, subsection 5 is constitutionally invalid to the extent that it permits the use of incriminating evidence in criminal proceedings, other than those for perjury or related offences. In the light of this decision, it might be concluded that Section 65, subsection 5 is constitutionally sound, since Section 65, subsection 2a(b) limits the scope of Section 65, subsection 5, and prohibits the admission of incriminating evidence in terms of the latter section in criminal proceedings, apart from proceedings on the ground of perjury and related offences. In Equisec Proprietary Limited versus Rodriguez and another, 1999, a debtor applied to stay the granting of a final sequestration order against his estate, arguing that exposure to compulsory interrogation would be prejudicial to him in criminal proceedings which were pending against him. The court rejected the application, holding that the debtor was adequately protected by Section 65, subsection 2a, since it would render incriminating evidence elicited at such an interrogation inadmissible in criminal proceedings. Although evidence given at an interrogation is admissible in civil proceedings instituted against the person who gave the evidence, it does not simultaneously serve as proof of the fact which it reveals. In this regard, the court must consider the evidence as a whole and decide how much weight should be given to it. The court may, if it sees fit, accord different degrees of credence or credibility to different parts of the evidence. Number 13.1.7. Failure to attend or submit to interrogation. If the insolvent or a person duly summoned to appear at a meeting of creditors failed to attend or remain in attendance at the meeting, the presiding officer may issue a warrant authorizing a member of the police to apprehend him, that is, the insolvent or person summoned, and bring him before the presiding officer, as per Section 66, subsection 1. Unless the insolvent or person summoned satisfy the presiding officer that he had a reasonable excuse for failing to appear or remain in attendance, the presiding officer may commit him to prison for a period which the officer may determine, as per Section 66, subsection 2. The officer in charge of the prison must then detain the person committed and produce him when and where required by the presiding officer. If a party summoned to an interrogation appears but fails to produce a book or document which he was required to produce, or if a person who may be interrogated refuses to be sworn by the presiding officer, it refuses to refuses to answer fully and satisfactorily any question lawfully put to him, the presiding officer may issue a warrant committing the party concerned to prison, where he must be detained until he has undertaken to do what is required of him, as per Section 66, subsection 3. In Nieuwoud versus Fort NO in andere 1987, it was held that where the party gives an answer which is incomplete or unsatisfactory, the presiding officer must decide whether this is due to an unwillingness to testify or whether the party has answered the question to the best of his ability. If the answer is clearly untrue or evasive, it may be considered to be a form of intentional refusal to answer the question. But if the answer is not nonsensical or evasive, even if it is improbable, it cannot be said that the party has failed to answer the question to the best of his ability. If, after being released on an undertaking to do what is required of him, the party fails to fulfill his undertaking, the presiding officer may commit him to prison as often as may be necessary to compel him to do what is required of him, as per Section 66, subsection 4. A person committed to prison in terms of this section may apply to the High Court for his discharge from custody, and the court may order his discharge if it finds that he was wrongfully committed or is being wrongfully detained, as per Section 66, subsection 5. The presiding officer enjoys the same immunity in connection with the apprehension or committal of a person as is enjoyed by a judicial officer in regard to any act performed by him in the exercise of his functions, as per Section 66, subsection 6. In De Lange versus Smits, N.O. and others, 1998, it was argued that Section 66, subsection 3, dealing with committal for failing to produce a document, take the oath, or answer a question satisfactorily, is constitutionally invalid because it violates Section 12, subsection 1b of the Constitution, the right not to be detained without a fair trial. The court accepted that the section is invalid, but only to the extent that it empowers a presiding officer who is not a judicial officer in the court structure established by the Constitution. In other words, a judge or a magistrate to issue a warrant committing an examinee to prison. It seems clear that the same reasoning applies to Section 66, subsection 2, committal for failing to appear or remain in attendance. Section 66, subsection 2 and subsection 3 should both, therefore, be read subject to the qualification that a presiding officer may order committal on the grounds stipulated in the sections only if he is recognized as a judicial officer in the court structure. In the longest case, Ackerman remarked as follows. It was suggested in argument that if the public service officers did not have summary committal powers, this would give rise to delays which would undermine the efficacy of the sequestration process. It is not self-evident to me why this must be so if creditors' meetings and courts are efficiently run. There is nothing before us to show why these public service officers cannot legitimately be accommodated in the magisterial judiciary and used exclusively to preside over creditors' meetings, or why, for that matter, specialist insolvency or bankruptcy courts cannot effectively be established under the Constitution in which their expertise can also be fully employed. As judicial officers with true structural and constitutional independence, there could be no objection to them committing examinees to prison. Number 13.1.8. Interrogation revealing possible offense. Where it appears from a statement made at an interrogation that there are reasonable grounds for suspecting that a person has committed an offense, the master must transmit the statements with any necessary documents to the Director of Public Prosecutions, to enable him to decide whether any criminal proceedings should be instituted in the matter, as per Section 67, subsection 1. Number 13.2. Interrogation by master. The Act also makes provisions for an inquiry to be instituted by the master, whenever he is of the opinion that the insolvent, the trustee, or any other person is able to give information which he, the master, considers desirable to obtain concerning the insolvent, his estate, the administration of his estate, or any claim or demand made against the estate, as per Section 152, subsection 2. In such a case, the master may summon the party concerned to appear before him or before a magistrate or an officer in the public service, at a stated time and place, and give the information. The master may exercise this power at any time after sequestration. It need not be shown that an interrogation under Section 64 or 65 is impossible or impractical. The master may administer the oath to the party summoned, and then the master and also the trustee, if the latter is not the person summoned, or his agent, may interrogate him, as per Section 152, subsection 4. After the interrogation, the master may require the person to appear again and submit further information or any book or document, as per Section 152, subsection 3. The relevance of these documents to the insolvent's affairs outweighs the rights of privacy under Section 14 of the Constitution of the Republic of South Africa, 1996. Certain provisions of the Act relating to interrogations by the trustee apply mutatis mutandis, those concerning privilege and the giving of incriminating evidence, those dealing with the failure to attend or submit to interrogation and the immunity of the presiding officer, and those governing witness fees, as per Section 152, subsection 5 to 7. So, for example, a witness need not attend the interrogation until offered the prescribed witness fees and allowances. The courts have accepted the following propositions regarding the nature and scope of an inquiry in terms of Section 152. Number 1. The inquiry is purely investigative in nature. The presiding officer investigates facts, but he makes no finding that can detrimentally affect anyone's rights, nor does he determine any rights. Secondly, Since the inquiry does not adversely affect anyone's rights, the master need not apply the odi alterum partem rule before deciding to hold the inquiry, and the presiding officer need not observe the rule while the inquiry is in progress. It follows that the master is not obliged to grant a hearing to a person summoned before issuing him with a notice to appear, and that he does not have to provide reasons for his decision to hold an inquiry. And the insolvent cannot demand to be present at the examination or to be given the opportunity to cross-examine the witness or witnesses. Number 3. In regulating and controlling the inquiry, the presiding officer must observe the dictates of procedural fairness, but this requirement does not mean that he must allow an examinee access to the information on which the decision to hold the inquiry was based. An examinee has no constitutional right of access to such information, in terms of Section 32 of the Constitution, read with item 23 of Schedule 6. Because the inquiry does not amount to administrative action and does not adversely affect the examinee's rights. Number 4. The inquiry need not follow any particular procedure. The presiding officer is not compelled to keep a record or notes of the inquiry and cannot be made to disclose any person, including the examinee himself, any informal notes which he kept of the proceedings. Number 5. A person other than the trustee is not entitled as of right to representation at the inquiry. However, the presiding officer will often allow representation, and the court has said that it is desirable that a person who is being interrogated should be permitted to have a legal advisor present to advise him of his rights, especially where the interrogation may constitute a step in litigation hostile to the witness. And lastly, because of the nature of the inquiry, the court's powers to review in terms of Section 151 is very limited. The court may interfere with the master's decision to hold an inquiry only if he acted mala fide, from ulterior motives, or failed to apply his mind to the matter. It may intervene in the inquiry itself only if it is conducted in an oppressive or vexatious manner, or might result in hardship to the examinee, or where unusual, special, or exceptional circumstances are present.